Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and this is the third video that I am going to give you guys today, and this is the final video on the United States versus Robert Sylvester Kelly. And so for those of you who are just checking out this video because it popped up in your suggestions, these documents that I have been reading today are post-trial documents for Mr. Kelly, who was found guilty on, I believe, 9 counts of racketeering and the Mann Act back in September. And of course, most of you may know Robert Sylvester Kelly as the R&B singer, writer, producer, R. Kelly. And so he has a new attorney. Her name is Jennifer Bonjean, and she is trying to get the judge in this case, Ann Donnelly, to either vacate the verdicts and give him a new trial, or to release him, to rule in their favor and to let him go. So in the prior 2 documents that I did today, one had to do with jury selection and Mr. Kelly stating that he was not a willing or an active participant, I should say, in his jury selection, and that his counsel basically just iced him out of the process, and thereby allowing people who may have had preconceived notions about him, who had watched the docu-lies that came out, the Surviving R. Kelly docu-lies, that they allowed these people on the jury. Therefore, he was denied the right to a fair trial because these people had already decided his guilt before the case took place, and that no reasonable jury, after sitting through the case and listening to the nonsense that was put out, would have found him guilty. And then in the other motion, it was actually a response from the Eastern District of New York, basically saying that they do not want the judge to delay his sentencing because his attorney, Jennifer Bonjean, had put forth a motion asking to delay sentencing, which is set for May 4th, until after the case that is going to be heard in the Northern District of Illinois starting on August 1st. She wanted the judge to delay that one because she felt that that information that he gives to the probation office, which does a report that the judge uses as a sentence in the sentencing guidelines to rather give him a lesser sentence or a harsher sentence, that some of that information could be fed to the Northern District of Illinois by the government, and therefore she wants to wait until after that case takes place. But the government is like, no, because his victims have waited long enough, and this has been going on for this long, and it's going to, many of them have waited decades to get justice, and it's going to cost the government to be flying him back and forth, but y'all been holding him for almost 3 years. So what is it going to cost you? What difference does it make if it costs? It's our money. It's the taxpayers that's paying for it. So why do you care? We've been paying to house him for 2.5 years. We can pay to fly him back and forth from Chicago to New York. Anyway, so now we're on to the third document. It says, Defendant Robert Kelly's reply in response to the government's memorandum of law in opposition to defendant's motion for a judgment of acquittal. So, y'all can go back. I did the video about a week ago. It was 109 pages. Actually, there were two documents filed by the government that totaled like 150 pages. But the one in question that Jennifer Bonjean is responding to in this document is the 109 page. Child, it was a work of fiction. Just go check it out. I'll drop the link above. So she does a table of contents. And basically in the table of contents, she is going to outline the government failed to prove defendant guilty of the offense of racketeering, count 1. And then she breaks down each section that she's going to go over. And then she will have her conclusion. And then she has a table of authorities. And these are cases that supports her position. And you guys remember in the prior documents, I stated how each side, as they're writing these motions, they're pulling past case law that supports their position. And it doesn't necessarily mean that the cases that they're citing are cases that are similar to Mr. Kelly's case. They're just cases that has a few lines in it, a few quotes from justices and opinions and that type of thing that supports the position that they are given. So whereas his case is about, sexual abuse, the cases that they are citing could be about corruption in banks. It could be about drug dealing. It could be, about murder. It could be about anything, not necessarily what his case is about. So the opinions, especially with the prosecution, the opinions that they're reading to support their opinion would not necessarily flow over to also support what they're saying about Mr. Kelly, if that makes sense to you guys. And so, and it goes both ways. I'm not saying that the defense isn't doing the same thing, but that's basically when I'm reading all this case law, that is what is going on, is that they found these snippets to support what they're saying. And it's no different than like when you're on social media and some story comes up about a celebrity or a case, and then people immediately go and start talking about something else that happened, and you're like, but that has nothing to do with this. Okay. So anyway, let's go on. I'm not going to read the total list to you guys. And then we're going to go down. She talks about the statues. I'm skipping over all of that because it's stuff that we've already talked about in past videos. So she jumps in and she says, number 1, the government failed to prove defendant guilty of the offense of racketeering, count 1. And then also for the people who are new and trying to wrap their brain about what's going on. So in these post-trial motions, the defense team has presented motions as to why they think Mr. Kelly needs a new trial or why he needs to be acquitted. And then the government had the opportunity to respond, and now the defense is doing their rebuttal, and hopefully the government doesn't get another rebuttal because we need this to wrap up at some point, I guess is what I'm saying. So 1, the government failed to prove defendant guilty of the offense of racketeering, count 1. A, where there was no common purpose to carry out a fraudulent course of conduct, the government did not establish an enterprise. And she's going to say it in the morning, in the afternoon, in the evening, that there was no enterprise. And over here, we agree with her. So the government concedes that its evidence did not prove that defendants' employees shared a common purpose of criminality, but contends that to demonstrate a RICO enterprise, it was only required to show that defendants' employees shared a common purpose to promote his music and meet his personal needs. Government response at page 49. It's either the page number or the line number. Despite authority to the contrary, the government insists that to prove a RICO enterprise, the members of the enterprise need not have a connection to any unlawful conduct. Response at 50. According to the government, so long as the persons associated in fact share a common purpose, a RICO enterprise may exist, even if those persons do not have a common understanding that the purpose of the enterprise is to carry out illegal or fraudulent conduct. Under the government's theory, an enterprise exists when any individual is engaged in a pattern of unlawful conduct, racketeering activities, and merely uses his employees to unwittingly facilitate that conduct. The government's argument is belied by the law and common sense. At the outset, the government is unable to provide a single case that supports its expansive view of RICO enterprise, nor is it able to identify any factually similar authority. Instead, the government repeats the refrain that an enterprise may constitute a legal entity, but this point is not in dispute. An enterprise can be either a formal or informal organization that conducts purely illegal activity or conducts largely legal activity. Any union or group of individuals associated in fact can constitute an enterprise. United States Code 18 at section 1961-4. However, to sustain a charge of RICO, the members of the enterprise must share a purpose of carrying out some course of unlawful conduct. And then she cites First Capital Asset Management versus Satinwood Incorporated, which was a case heard in the Second Circuit in 2004. If this was not the case, a RICO enterprise could be established by one bad actor using his employees, his neighbors, or even his friends to unwittingly facilitate that misconduct. The framers of the RICO statute did not intend this absurd result, and courts have not hesitated to reject the expansive view of a RICO enterprise. Strangely, the government cites Moss versus BMO Harris Bank, which was heard in the Eastern District of New York in 2017, to support its argument, but Moss strongly supports defendant's position. There, the plaintiff brought a punitive class action against First Premier Bank, alleging RICO violations. Specifically, the plaintiff charged that First Premier Bank, a formal legal entity, belonged to the Automated Clearinghouse Network, a payment processing system that processed unlawful ACH transactions on behalf of payday lenders. The plaintiff argued inter alia that the ACH network constituted an enterprise consisting of originators, various depository financial institutions that received ACH transactions instructions, ACH operators, and third-party service providers, all of which shared the common lawful purpose of facilitating batch processing of electronic payments for and between participating depository financial institutions. The court concluded that the ACH network described by plaintiff did not constitute an enterprise for RICO purposes. The court held that to satisfy the first prong of the Boyle test, the participants in an association in fact enterprise must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. Emphasis in the original, citing New York versus United Parcel Service, which was heard in 2016, and then in the Southern District of New York. And then quoting First Capital Management, and then they tell where they're getting the information from, the page number and that stuff. The court dismissed plaintiff's Section 1962A claim, finding that plaintiff's failure to plead an association in fact enterprise that shared a wrongful intent to violate RICO was fatal to the claim. And then they cite Cruz versus FX Direct Dealer, which was heard in the Second Circuit in 2013, affirming dismissal of association in fact RICO claim, where the amended complaint admitted that certain participants in the purported enterprise were not aware of deceptive practices at issue. First Nationwide Bank versus Gelt Funding from the Southern District of New York in 1993, and then appealed to the Second Circuit in 1994. The Moss Court expressly rejected the plaintiff's enterprise theory, finding it implausible that all of the institutions that allegedly made up the enterprise possess the unlawful intent required to transform that cooperative into an associate in fact enterprise for RICO purposes. And then she cites some other cases that were heard in the Southern District of New York in 2014 and by the Second Circuit in 2015, dismissing RICO claims that allege that defendants used the mortgage electronic registration system to conceal unlawful mortgage transactions because plaintiff failed to show coordinated activity to jointly achieve a common fraudulent purpose, emphasis in the original. And so before I continue, let me kind of like wrap it up. Like, I know it's a lot of technical jargon, but basically what she's saying is that these lawsuits were brought. Now, you all know what ACH is how we pretty much bank today. Like, you swipe your debit card at the grocery store. That's an ACH transaction, because then the merchant gets that money based on the fact that your bank approved the transaction, and then the bank at some point actually sends the money to the merchant. And so basically what the cases proved was that you couldn't say that the ACH network was an enterprise because they accepted both legal and illegal transactions, because the people who were not breaking the law had no knowledge that other people were breaking the law and putting through these illegal and fraudulent transactions. So you can't say that they were an enterprise when there were both people doing good and people doing wrong. And so that relates to Mr. Kelly's case in the fact that the government is trying to say that his employees and people around him were his enterprise, even though they didn't know that he was committing crimes. But because they worked for him, they took orders from him, they did their job that they were hired to do, that they somehow was the enterprise, even though they didn't know that by working for him that they were somehow helping this illegal activity that the government claims was taking place. So moving on. So critically, the plaintiff in Moss argued that the defendant bank shared a common purpose of the ACH network and used the ACH network to originate lawful and legitimate transactions, but also used its role within the ACH network to participate in the collection of unlawful debts. Relying on Anctil Supra, the Moss Court observed that at best, the defendant used a legitimate network to advance its own illegitimate business interests, and that the alleged illicit ACH transactions did not render the ACH network a RICO enterprise absent a common purpose among the other network participants to violate RICO. The Moss Court's logic applies with full force here. The government's evidence showed that defendants' so-called inner circle, more aptly described as his employees, worked to promote defendants' music and brand, a legitimate enterprise. At best, the defendant's evidence showed that the defendant used his role within his music-driven collective to participate in private sexual misconduct. As in Moss, defendants' use of his otherwise legitimate music business to advance his allegedly illegitimate sexual needs does not render defendant's business organization a RICO enterprise, absent a common purpose among his employees to violate RICO. Thus, the government's RICO enterprise theory fails. Courts have rejected the government's expansive theory of a RICO enterprise because it would extend RICO liability to a vast marketplace based on one bad actor's mere association with the other members of that collective. Now we're going to get into what many of us have been saying all along. Like, if this is a RICO, then a whole bunch of other people need to be in jail, right? So she says, by way of example, Under the government's theory, both Fox News and NBC News constitute RICO enterprises because of the bad conduct of Roger Ailes and Matt Lauer, respectively. Roger Ailes, the former CEO of Fox News, allegedly sexually harassed, inappropriately touched, and exposed himself to women, some as young as 16, while working at Fox News. Under the government's expansive interpretation of enterprise, Fox News and its employees who work for Ailes, his assistants, his secretaries, his drivers, etc., constitute an enterprise for RICO purposes because they presumably shared a quote-unquote common purpose to promote Fox News and meet the needs of its CEO. By the government's logic, if Ailes' assistants carried out tasks such as scheduling appointments, arranging transportation, or making such reservations for Ailes, and women he harassed or assaulted, those assistants constitute members of a RICO enterprise irrespective of their knowing involvement in Ailes' unlawful conduct. The same can be said for Matt Lauer, former NBC News anchor who was accused of repeatedly harassing and assaulting his female colleagues, sometimes while traveling for work. Consistent with the government's theory, any of Lauer's assistants, handlers, drivers would qualify as members of an enterprise for RICO purposes if in the course of their duties they facilitated Lauer's illegal sexual conduct, even unwittingly. Of course, the government has shown no willingness to use its aggressive RICO theory against powerful white men. But the fact remains that if its RICO enterprise theory in the case is sanctioned, the government will have virtually unlimited power to charge a single bad actor with RICO. And that is all we have been saying all along. In sum, the government concedes that it failed to establish an enterprise when it offered no evidence that defendants' various employees over the course of 2 decades engaged in coordinated activity to jointly achieve a common fraudulent purpose. As summarized by the government in its opposition papers, the evidence at trial showed only that defendants' employees generally engaged in a variety of tasks that supported defendants' relationships, not that they performed activities with the purpose of supporting illegal conduct. Because the government failed to prove that the members of defendants' so-called inner circle acted jointly to achieve a common fraudulent or illegal scheme, this court must acquit defendant of RICO. B. The government's evidence of an enterprise distinct from the defendant was wanting. The government insists that its proofs satisfied the person enterprise rule. The government insists that its proofs satisfied the person enterprise rule because the enterprise consisted of more than the defendant. The government's summary conclusions are not backed up by the evidence. The government argues that the purpose of the enterprise was to promote defendant, his music, and his brand, and to ensure that his needs were met. Illogically, the government argues that the enterprise was distinct from the defendant, but fails to identify evidence to support the contention. Frankly, the government seems to concede that the defendant is the enterprise and that the enterprise simply does not exist without him, which explains why it failed to charge even one person in connection with the alleged vast RICO enterprise. The government offers only a feeble response to defendants' discreteness challenge, citing no authority to support its contention of distinguishing the holdings of Riverwoods Chappaqua Corp. Versus Marine Midland Bank, which was a case heard in the Second Circuit in 1994, and Discount Inc., New York Next Corporation, which was heard by the Second Circuit in 1996, by alleging a RICO enterprise that consists of defendant and his own employees, agents carrying on his affairs, namely promoting his brand, his music, and even facilitating his sexual needs. The government fails to satisfy the distinctness requirement. But put differently, because the government alleged that defendant's employees associated together for no purpose other than to carry out defendant's needs, including his sexual activity, the employees did not form an enterprise distinct from defendant. Defendant and the alleged enterprise were one and the same. And I know that sounds very confusing, but basically what she's saying is there was no RICO, there was no organized crime going on, because these people were basically just doing their job. We're talking about the music industry, where we just know there's a lot of foolishness going on, right? And so if your job is, if you're a runner and the boss says, hey, run over there and give this girl my phone number, or give this woman my phone number, then you're just doing what your boss told you to do. You have no preconceived knowledge of, well, you probably do have a preconceived knowledge. You probably think you want to have sex with her, right? Because you're thinking that, well, she's a groupie, she's at the party, I'm going to give her the number, and then it's up to her to do whatever she wants with the number. So in the employee mind, there is no illegal crime taking place, right? And so you can't say that by doing their job and doing what they were paid to do, that they somehow become a part of this illegal organization, and then on the flip side, not charge them with a crime. So you have a RICO, you have a criminal organization, but the only person that you're arresting is the person that's over the organization. You're not arresting the people that help sustain the organization, is basically what they're saying. So then we move over to B. The government failed to prove that the so-called enterprise's activities affected interstate commerce. The government's interstate commerce argument hinges on its theory that the purpose of the RICO enterprise was to promote defendants' music and brand. As argued supra, this RICO enterprise theory fails because there is simply no nexus between the collective of individuals who work to promote defendants' music and a course of fraudulent conduct, or the racketeering activity in which the defendant is alleged to have engaged. If defendants' legitimate music collective constituted an enterprise for RICO purposes, the government's argument would be well taken. But for the reasons identified supra, the government cannot prove a RICO enterprise based on individuals associated, in fact, for the purpose of promoting defendants' music. And then let me also add this, going back to how they were saying that Fox News and NBC News, basically would have formed this enterprise based on the conduct of Ayers, Ailes, and Lauer. We can also say the same for Sony Music, because the machine, the R. Kelly machine could not exist without Sony Music, right? Because they funded the machine. He was their employer. And this is where the whole copyright thing comes into play, and the owning of, the music and whatnot, is because the reason so many musicians lose the rights to their music is because in the contract it says that it is a work for hire, that these people were hired to produce this music, and therefore they have no rights to the music. So that's the argument that music labels give when these musicians and these artists go to claim their music back, right? After the copyright, was it 20 years, 30 years, however long the copyright laws are, and they go back and say, okay, now I want my rights back. They say, oh no, this was work for hire. So that's another angle that the lawyers could have took in this whole RICO thing, is that Mr. Kelly was technically an employee of Sony. Therefore, Sony is the enterprise, because they employed him and then allowed him to go out and do these alleged crimes, and that they had an obligation to pull him in and not, allow this behavior to continue. In addition, by naming Sony as the enterprise, then you get to see the financial trail for the settlements that were paid to these different people. Who wrote those checks? Where did that money come from? Like I guarantee you, there would have been a trail where Sony said to Barry Hankerson, Darren McDavid, whoever else was involved, make this go away. And then they went to the lawyer. The lawyer said, okay, well, we're going to settle this for, $1 million, $500,000, however much money. And I guarantee you, if he did not have that money in the bank, which he probably didn't, Sony funded that money to pay those settlements. And that's how these musicians, they get trapped, because the music label is just putting out money to the artist that the artist is never going to be able to repay when they come to the end of their contract. Because when they come to say, okay, my contract is over, I want the rights to my music so I can move on, and then the music label comes out with a tally of all the millions of dollars that they have fronted, and they say, okay, when you pay us back all this money we have fronted to you for these various things, then we'll consider giving you the music back. But they know that these guys are so irresponsible with their money that they'll never be able to pay them back. So really, Sony is the enterprise, if we want to go that route. And I'm so surprised that was not part of his legal strategy. It just boggles my mind that none of the attorneys decided to go that route and say, well, he was an employee of Sony, and so therefore Sony has a bigger responsibility because they fueled the machine, right? Anyway, so we're going to move on to C. The government's proof did not establish a pattern of racketeering. 1. Production of sexually explicit material, Racketeering Acts 2, 7, and 10. The government charged defendant with 3 violations of United States Code 18, Section 2251A, for allegedly 1. Videotaping a consensual act with 17-year-old Stephanie, 2. Videotaping a sex act with 17-year-old Ariel in the state of California, where the age of consent is 18, and 3. Videotaping a sex act with Geronda in Illinois before she turned 18 years of age. The government argues that it provided sufficient proof of these Section 2251A violations because the defendant used the minors to take part in sexually explicit conduct for the purpose of producing a visual depiction of the conduct. The government argues that pursuant to authority in the circuit and others, proof that defendant photographed or videotaped the persons without more is sufficient evidence, or videotaped without more is sufficient evidence of Section 2251A. That doesn't make sense to me. Violation because videotaping the minor alone constitutes the use of the minor. United States versus Serial, Second Circuit in 1996. Although it is true that several circuits, including the Second Circuit, have held that the use element set forth in Section 2251A is satisfied when a defendant intentionally films a minor's sexually explicit conduct, defendant maintains that use requires more than a minor appearing in a photograph or video. To reach a different conclusion would render the remaining terms in the statute, persuade, induce, entice, or coerce, superfluous. It is a cardinal principle of statutory construction that a statute ought upon a whole to be construed that if it can be prevented, no clause, sentence, or word shall be superfluous or insignificant. And then she cites several cases. It says, if, as the government argues, Section 2251A violation is established by nothing more than proving that a defendant photographed or videotaped a minor in explicit conduct, the terms persuaded, induced, enticed, or coerced are entirely unnecessary. To accept the serial court's interpretation, of the word use is to render the remainder of the sentence meaningless, in direct contradiction to principles of statutory construction. To read the statute where each word has significance requires a court to define use as something more than the act of photographing the minor. Defendant acknowledges the authority to the contrary, but maintains that the law is contrary to the intent of the framers of the statute. Now, that was just a whole bunch of jargon to say that, okay, maybe you got a point there, but we're still disagreeing with you. So, 2, Mann Act violations, exposure to STDs. A, Racketeering Acts 8A and 12A intent. In keeping with its dichotomous approach to statutory interpretation, the government argues that even though it charged Mann Act violations based on defendants' violations of state public safety laws prohibiting knowing exposure to STDs, the government denies that it must prove that defendant arranged travel of Ariel and Faith with the intent to violate those laws. With no authority, the government argues that it was sufficient to show only that one of defendant's motivations in arranging for Ariel and Faith to travel to meet him during his music tours was to have sex with them, not to violate the charged offenses. The government simply ignores its obligation to prove a nexus between the transportation and the alleged illegal conduct. This is a recurring pattern in the government's prosecution of this case. The illegal sexual activity that the government charged are specific offenses pursuant to the California and New York public health codes. The record is devoid of any evidence that a significant or motivating purpose in arranging for Ariel and Faith's travel was to expose them to an STD. The government devotes 6 pages of its discussion to reviewing the copious amount of testimony it presented in connection with defendants' alleged conduct of having unprotected sex with Ariel and Faith, and then in parentheses it says, who never contracted genital herpes in any event. And they're referring to Faith, who said that she had a cold sore. She never said she had genital herpes. But none of this testimony demonstrates that defendants' actions of arranging for Ariel and Faith to travel to meet him was motivated by an intent to expose Ariel and Faith to STDs. The government continues to ignore the salient argument here, namely that it failed to show that defendant was motivated to have Ariel and Faith travel to meet him so that he could expose them to an STD rather than to have sex with them. Okay, so basically he wasn't trying to give them herpes, so how are you going to charge him with knowingly exposing them, is what she's saying. B. Racketeering Acts 8B and 12B, persuasion, inducement, enticement, or coercion. The government continues to push a narrative it knows to be false, namely that defendant induced, enticed, coerced, or even persuaded Ariel or Faith to travel to meet him in California and New York, respectively, to engage in illegal sexual conduct. The undisputed evidence shows nothing of the sort. In both scenarios, defendant asked Ariel and Faith to meet him at his concerts, and they accepted. Both young women were eager to meet defendant and did so with a clear understanding that it would likely involve sex. And if they didn't know it the first time, they definitely knew it each time after that, right? Because if on the first time you meet with a guy and he wants to have sex with you and you don't want to have sex with him, you're not going to go and meet him again, right? You're just going to be like, nah, I think I'm going to pass. But no, they went, they engaged. They went, they engaged. They went, they engaged. It was continuing pattern of consensual activity. And so, as set forth in detail in defendant's opening papers, Ariel's contemporaneous text messages with her mother show that Ariel's mother engineered Ariel's relationship with defendant. And guys, I'll drop the link to the video where we read those text messages. The text messages reflect that Azriel and her mother communicated incessantly about how Azriel could entice defendant into a relationship that Azriel's mother hoped would catapult her into stardom. Lord help me. Prior to traveling to California, Azriel's mother demanded that she continue to text defendant. You better be texting him so you will stay on his mind. Jane, or Azriel, dutifully reported to her mother that she had spoken to defendant about flying to California to meet him, and that defendant told her that she could meet him whenever I tell him, tomorrow if I choose. As the government concedes, defendant had no idea that Azriel was 17 years old, since Azriel and her parents actively misled defendant about her age. During her trip to California, the defendant, Azriel, and her mother were in constant communication. Azriel never once complained that she had been enticed or on false pretenses or that she felt misled. Quite the opposite. The text messages reflect that Azriel was having the time of her life and thrilled to be romantically connected to the defendant. And you guys, let me pause there. Did you see the unedited video that Shabazz released? I wonder if Bonjean, like if she goes to the appellate court, will she be allowed to use those videos? Because I'm trying to figure out, like, is he trying to be strategic in helping? Is that why he's like releasing this stuff, aside from trying to build his channel, off the R. Kelly story? Is he trying to strategically give information to the defense that they can use during the appeals? Because he just put the whole unedited tape out there. It just seems to me that they should be able to use that at some point to prove that Azriel was full of crap. And if you haven't seen it, go watch it, because she basically just contradicts herself over and over and over again. And that interview actually took place after she left Trump Tower in early November and before the fight with Jocelyn, where she strategically, caused that fight and then decided she was going to turn against Mr. Kelly. So similarly, Faith's testimony on this issue shows that defendant asked her if she wanted to hang out. Faith agreed, and defendant merely paid for her travel. The record is devoid of any evidence or of persuasion, enticement, or inducement on the part of the defendant. Faith may have decided to travel and hang out with defendant because she sought to be near a celebrity, but this motivation on her part had nothing to do with defendant's conduct. Defendant's status as a famous R&B singer does not amount to enticement, notwithstanding the government's argument to the contrary. Right, because they make women seem stupid, that just because somebody's a celebrity that you're suddenly overwhelmed and your brain doesn't function correctly, and this person just takes control of your mind and makes you do things that you otherwise wouldn't do. The government suggests that defendant's acts of arranging for Azriel's travel is sufficient to demonstrate that he induced her to travel to California because he caused her to travel. The law says otherwise. The Second Circuit has made clear that the terms persuade, induce, entice, and coerce are words of common usage that have plain, ordinary meanings. United States versus Wakar, Second Circuit in 2021. United States versus Gagliarda in the Second Circuit in 2007. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality, recognizing that there might be some uncertainty as to the precise demarcation between persuading, which is criminalized, and asking, which is not. Keeping with this pattern of rewriting statutes, the government suggests that it need only prove that defendant caused Azriel and Faith to travel to meet him to sustain the charge. The government relies on a 1959 case from the Fourth Circuit that interpreted the now defunct version of the Mann Act that was historically used by the government to persecute black men who had relationships with white women. Harms versus United States, 4th Circuit, 1959. The current iteration of the Mann Act does not contain the cause language that the 1958 version did. Moreover, as discussed in detail, infra harms actually stands for the proposition that the government must provide specific proof of persuasion to sustain its burden. The government's reliance on harms is misplaced. Contrary to the government's claim, it was required to prove beyond a reasonable doubt that defendant persuaded, induced, or coerced Ariel to travel to California, not merely asked. The government's evidence was wanting. The court must acquit the defendant of this Mann Act violation and all others. C. New York Penal Law 120.20. The government charged defendant with a violation of the Mann Act as to faith based on the theory that he committed the offense of reckless endangerment when he had unprotected sex with her in New York without disclosing he suffered from genital herpes. The government again rehashes its excessive herpes testimony, insisting that a reasonable jury could easily conclude from the trial evidence that defendant created a substantial risk of physical injury when he had unprotected sex with Faith. Taking the government's evidence in its best light, it failed to prove that when defendant had sex with Faith, he created substantial risk of physical injury. First, because Faith was not afflicted with herpes and did not testify that she observed any evidence that defendant had an active infection. The only reasonable inference to draw is that defendant did not have any type of outbreak when he and Faith had sex in New York. The government insists that this fact is irrelevant, but whether defendant was engaging in unprotected sex while suffering from an active infection or during a period when he had no symptoms is entirely relevant to his state of mind and relevant to the issue of whether he acted recklessly. Surely the government would argue that it is more reckless and the risk of harm is more substantial if defendant had unprotected sex with Faith during an active outbreak. Thus, the question of whether Faith was infected with herpes in New York is relevant to defendant's state of mind and whether he acted with the requisite intent. Furthermore, the government's evidence simply did not prove that there was a substantial risk of death or serious physical injury. As argued at great length in defendant's opening memorandum of law, the government's herpes expert testified at length about rare complications of herpes that arguably would qualify as serious physical injury. But unless those risks were substantial, the government cannot meet its burden. Since the risk of serious injury associated with herpes is low rather than substantial risk, the government failed to prove reckless endangerment. D. New York Public Health Law, Section 2307. For the reasons fleshed out in defendant's opening memorandum, New York Public Health Law 2307 is unconstitutional. It fails to define infected. While the government and the court assumes that infected means carrying the virus rather than having the ability to transmit it, no authority supports this interpretation. Such an interpretation would lead to arbitrary and discriminatory enforcement as it did in this case. As a reminder, the government can point to no case in which an individual was charged with a violation of this public health law where the accused did not even transmit a disease to the alleged victim. And they are contending once again that he did not give Faith herpes, genital herpes, which the law is about. Instead, when she went to the doctor, it was because she had a cold sore on her mouth. And that's when she, I guess, was diagnosed with, there's two different forms. There's the cold sore and then there's the genital herpes. And she had the cold sore, which does not apply, I guess, to this law. And then it says E, violation of California Health Safety Code, Section 120290. The government argues that it was permitted to charge defendant with a repealed statute and rewrite it so that it would pass constitutional muster. Unsurprisingly, the government has no authority to support its view that it can take up the role of the California legislature. For unknown reasons, the government relies on a 1978 case out of the Third Circuit that fails to support its claim that it has the authority to charge and prosecute repealed statutes and to further step into the shoes of lawmakers and rewrite statutes of its liking. The government also inexplicably cites United States versus Bonjean, which was heard in the Eastern District of New York in 1988, which considered whether a certain charge violated the ex post facto clause since the alleged conduct occurred prior to the enactment of the statute. The issue raised here is different. The question before the court is whether the government was permitted to charge a version of the statute that did not exist at the time of the prosecution. The United States Supreme Court answers that question in the negative. The government points this court to no competent authority demonstrating that the antiquated version of the California public health law may be kept alive. As such, the government had no authority to charge and prosecute defendant under a repealed and inoperative statute, United States versus Chambers, and that was a case in 1934. Then 3, Racketeering Act 5, Mann Act violation, Gironda. The government expresses some confusion over defendant's interstate commerce argument. To be clear, defendant did expressly argue that purely interstate use of cell phones does not constitute use of a facility or interstate commerce. Defendant did more than vaguely suggest this argument, as the government contends in footnote 28. Defendant cited authority to support the proposition, namely Gonzalez versus Wretch from 2005, and further acknowledged a Second Circuit case that arguably conflicts with Gonzalez. The issue is properly preserved and presented to this court. If the court would like additional briefing on this issue or the many others raised in defendant's Rule 29 motion, it certainly has the authority to order it. If it wasn't clear enough, defendant argued in the alternative that even if interstate cell phone use does satisfy the Commerce Clause requirement in some circumstances, it did not do so here. The government showed only that Gironda and the defendant sometimes communicated by cell phone. The date and nature of those communications are unknown. The government asked the jury to assume that defendant induced, persuaded, enticed, or coerced Gironda to engage in prohibited sexual activity during their cell phone communications without providing the communications or even eliciting testimony from Gironda about what the communications reflected. The government routinely attempts to avoid nexus requirements and must be reminded that the government was required to show that defendant used the cell phone to commit the specific prohibited act, namely to induce, persuade, or coerce Gironda to engage in unlawful behavior. The government cannot satisfy that burden by generally showing that defendant and Gironda sometimes communicated by cell phone and that on some unrelated occasion they engaged in unlawful activity. The language used in those communications, to the extent they existed, is important for determining whether the defendant induced, persuaded, enticed, or coerced, or merely asked Gironda, which would be insufficient to demonstrate criminality. And then they cite United States versus Walker again, which was heard in the Second Circuit in 2021. And then United States versus Gagliotti, which was in the Second Circuit in 2007. While the government cites some authority to support its contention that interstate commerce can be established by interstate cell phone use, none of the cases cited by the government condone asking a jury to assume the content of those communications as the government did here. It says in United States versus Vickers, Second Circuit, 2017, the defendant was charged with a Section 2242A violation, not a violation under 2242B. The Vickers court was never faced with the question of whether the government can satisfy its burden of proof without ever introducing the communications that it claims constituted persuasion, inducement, or coercion, nor was the Vickers court faced with an interstate commerce question. And you guys, if you follow my reading of the transcripts, I talked about how when they got to that part about all these phone calls that allegedly happened between him and Geronda's mom, and Ruby Chris, whose real name I think is Jermaine Maxey. So we don't know if, like, what was going on in all these communications, because we know that Geronda and Ruby Chris had something going on, because when she got the settlement money, she gave him, I believe it was $4,000. And so we don't know if, like, this phone that they're claiming that him and Geronda were communicating with, that could have been Ruby Chris's phone, but maybe R. Kelly was paying for the phone. The phone was in R. Kelly's name, because I still can't understand, and they never clearly explain, why was he talking to Geronda's mother? Why was all these phone calls taking place? And I really believe that the phone calls were actually between Ruby Chris, Geronda, and Geronda's mother, as they were talking about getting some money. Because that's the only logical explanation. Because if you say that Mr. Kelly was actually in communication with Geronda's mother, then Geronda's mother had an obligation to say to him, hey, do you know my daughter is only 16 years old? Why are you talking to my daughter? But we don't seem to get any of that from what the government presented. And so that's why Ms. Bonjean is saying, like, you're talking about these communications, but where's the proof that this is what was said on those communications? So acknowledging the problems with this proof. And then also when I was talking about these phone conversations or these phone records, when I was reading the transcripts, I even pointed out the fact that they were becoming so technical, and it was just going, when they was reading this stuff out, it was so technical that the average person did not understand what they were saying. And that's how they convinced the jury that a lot of this stuff actually happened, because they just started coming in with all this stuff from the Homeland Security, information technology experts, and they were reading all this technical jargon, just confusing the hell out of everybody. And so the jurors probably were sitting there saying, well, these people are far more educated than us. They know what they're talking about. So we're going to assume that this story there, or this narrative that they're trying to give us, is factual and actual. And so we're going to believe them because they are the experts, and they, wouldn't come in here and lie. But really what they were doing was just reading all this technical information. And then the prosecutors led the jury into what the technical information meant. And then it even got to a point where I think that the prosecutors were confusing themselves, because the testimony abruptly ended. Like, they realized that they didn't even know what they were talking about at that point. And so then they, moved away from it. But it went on for just over and over and over. Like, it had been hours that those people were up there. I mean, I know it took me an hour to read it all, so I don't know how long they were actually on the stand. But anyway, moving on. It says, acknowledging the problems with this proof, the government relies on Blumenfield versus United States, which was heard in the 8th Circuit in 1960. It says, a 60-year-old case out of the 8th Circuit that interpreted the repealed and outdated Mann Act statute. That aside, Bloomfield involved a defendant arranging for a prostitute, Miss Tollefson, to cross state lines for the purpose of prostitution, where the evidence showed that defendant telephoned Miss Tollefson for the precise purpose of hiring her to cross state lines and engage in prostitution in exchange for money. It is no surprise that a jury concluded that the defendant used the telephone to induce Miss Tollefson across state lines for prostitution. In contrast here, Geronda testified that she had a sexual relationship with defendant that was carried out entirely in the state of Illinois. She did not describe herself as a prostitute and admitted that she went to parties at defendant's home, hung out there for extended periods of time, and even went to defendant's home when he was not there. Although the government offered general evidence through Geronda's testimony that Geronda and defendant sometimes communicated by cell phone, it simply failed to prove that defendant used the phone to persuade, induce, or coerce Geronda into unlawful sexual activity. The government's proof was insufficient as to Racketeering Act 5. 4. Racketeering Act 9, Ariel. In response to defendant's claim that the government failed to prove the defendant took any action to induce, persuade, entice, or coerce Ariel to travel to California between September and October 2015, the government again relies on the pitiful 1959 Fourth Circuit case Harms versus United States, claiming that inducement simply means to cause. Harms does not stand for the proposition the government contends. Indeed, Harms supports defendant's argument. In Harms, the question at issue was whether the government proved that the defendant directed or knew that the victim would travel by common carrier. The victim had previously worked for the defendant as a prostitute, and after having a conversation with the defendant, she traveled across state lines by interstate airline carrier and thereafter engaged in acts of prostitution in establishments maintained by the defendant. Evidence that the defendant had induced the victim to travel for the purpose of prostitution was ample. However, the defendant argued that the government's evidence was insufficient to show that the defendant either directed or knew that the victim would travel by common carrier. The Fourth Circuit concluded that it was not essential for the government to show that the defendant directed or knew that the victim would travel by interstate carrier. The court reasoned that because the government proved inducement, the fact of the resultant trip by interstate carrier was sufficient to justify a conviction under Section 2422. The court held it was not necessary for the government to go further and attempt to show that Harms, the defendant, knowingly caused the victim to travel by common carrier either by direction or knowledge that the victim, Bruno, would use that mode of transportation. Cause is a word of very broad import and its meaning is generally known. The knowing persuasion to make the interstate trip, of course, must be shown with some degree of particularity, but once the knowing persuasion has been shown, if the trip by interstate carrier follows, the offense is complete. And they are citing information from the Harms case. So contrary to the government's argument, Harms does not hold the inducement or persuasion means cause. Quite the contrary, Harms makes clear the government must show persuasion to make the trip with some degree of particularity. The court merely noted that once the government proves persuasion, it is not required to separately show that the defendant knew how the victim would travel across state lines. Here, the government did not demonstrate persuasion, inducement, or coercion. Ariel offered no testimony to suggest that she was coerced or enticed into traveling to California in the fall of 2015. The record shows that Ariel was desperate to return to the defendant after he sent her home and was eager to travel with him. Ariel's testimony about defendant's rules and sexual proclivities during this time period are not sufficient evidence of coercion to travel, even if Ariel now believes with the benefit of hindsight that defendant's conduct was controlling. 5. False labor racketeering acts. The government contends that Geronda's act of giving oral sex to defendant on one occasion in January 2010 was an act of forced labor. As set forth in detail in defendant's opening memorandum of law, the forced labor statute was not intended to punish isolated acts of abuse, but even if it was, the government did not show a nexus between the physical assault and the sexual assault. Taking in its best light, the government offered evidence that on one occasion, Geronda threatened to punish, I think she meant the defendant threatened to punish Geronda for breaking into his home and physically assaulted her on a separate occasion because she failed to show him proper respect. Geronda did not testify that the physical assault was intended to force her to perform oral sex on defendant. This evidence falls painfully short of proof of the offense of forced labor. Geronda could have testified that she gave defendant oral sex because he threatened her or because she feared he might assault her, but those words never came out of her mouth. Random acts of violence plus a sex act does not equate to forced labor. The government should not be permitted to warp statutes beyond recognition simply because it seeks to punish isolated acts of abuse that occurred decades ago. Similarly, the government did not prove that Ariel engaged in group sex acts because she was forced to. Ariel's hindsight testimony, hindsight testimony that she did not want to participate in that conduct is not proof that she was forced to. The government cannot establish the offense of forced labor by simply showing that defendant and Ariel had a sexual relationship that some might consider abusive. The government was required to establish a causal link between the group sex acts and threats of physical violence. It failed to do so. Finally, no rational juror could conclude based on the evidence adduced at trial that defendant knowingly obtained or agreed to obtain any labor or services from Faith on January 13, 2018. As discussed supra, the forced labor statute was not intended to reach isolated conduct like that described by Faith. Faith never testified that she felt forced to perform oral sex on the defendant. Not wanting to have oral sex is not the same as being forced to engage in it. Furthermore, Faith admitted proudly that she was not a victim and made a choice to be involved with defendant. When she was displeased with the relationship, she walked away. The government's infantilization of Faith and quest to redefine her experience as forced labor is offensive to women who actually live in conditions of servitude. The harm that the forced labor statute was designed to address. For the foregoing reasons, the court must acquit the defendant of all forced labor convictions. Conclusion. For the foregoing reasons, this court should enter an order acquitting defendant of all offenses. Respectfully submitted, Jennifer Bonjean. Okay, guys, well, that's it. Okay, that was her response. And I pray that the government doesn't get to come back and respond to her response, because this could go on forever and ever and ever. And I think by the government writing that long motion, that 109-page response, like they kind of just put too much information on the record. And I think I stated in one of the previous videos that I did, like, could the strategy that Jennifer Bonjean is using is to force the government to put all these crazy arguments on the record, because she probably has zero expectation or very little expectation that Ann Dunley is going to overturn the conviction or grant a new trial. But she's forcing the government to put all of their crazy assertions and their tactics and their thought process on record, so that when she does go to the Second Circuit, she can then like shred it apart and be like, can you see this craziness that they're saying? And then to point out what we've been saying all along is that the stuff that they're charging this man with is stuff that people do in their everyday life. Like, people pay for their girlfriends to go on trips, pay for their mistresses to go on trips, you know, in other countries, in other states. And so when the relationship goes bad and then the woman wants to say, oh, he forced me to do this, then you can come back and charge the Mann Act, because the Mann Act is so vague that anybody can be charged with it. If you pay for somebody to go across state lines and you have sex after you get across state lines, technically you could be charged with the Mann Act. And then I also like the fact that she brought in about, you know, the Matt Lauer and the Robert Ailes situation, because technically that is the same thing that they're charging Mr. Kelly with, but these people get to just ride off in the sunset. I think Matt Lauer was paid like $20 million to leave NBC. Do you think he's bothered? Do you think he cares? But he's not being charged with any crime. And you have, you know, everybody's waiting on, what's the lady, Anne? Oh, she has the dark hair, real tan lady. Anne, her last name begins with a C. Like everybody is waiting on her to tell her story, but for some reason she doesn't seem to ever going to tell us what really happened between her and Matt Lauer. But the government isn't going to her and trying to force her into telling whatever it is that happened between them. We have all this stuff about him having the lock, you know, had the button on his desk where when the women would come into his office, he would lock the door. Isn't that false imprisonment? Like, why is he not being charged with a RICO? You know, because the government knows that they can't go against a Fox News or NBC the same way they know they can't go up against Sony, which is why Sony isn't being charged as the actual RICO in this case. But anyway, that's it for me. Oh, one other thing I wanted to talk about was Geronda. I would just love to be a fly on the wall when Jennifer Bonjean is talking to Mr. Kelly, because I want to know, like, did he really, really, really have a relationship with Geronda? Like, I just, like, of all the crazy stories that have come out, the one about Geronda, is the one where I'm just like, could you really have sunk that low as to get involved with this crazy, goofy girl? But then I guess a groupie is a groupie. Like, if you're looking at these women as groupies, you're not really looking at them as, say, wifey material, then I guess you could be involved with a Geronda. But I am just really wondering, was there really this relationship that Geronda claims that they had? I would just love to know what he is telling Miss Bonjean about Geronda. Anyway, guys, that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.